Good morning. My name is Chanel Peterson. I am the Managing Director for the Virgin Islands Economic Development Authority in Marketing and Vision 2040. And for today's VIEDA Wednesday webinars, we have Americans with Disabilities Act and Family Medical Leave Act during the pandemic with our partners, the Disability Rights Center of the Virgin Islands. For future webinars, as well as the recording of this webinar, you can always visit www.usvieda.org/webinars. Now, this webinar, we have unfortunately had to reschedule a couple times due to conflicts with some key initiatives being held by the governor. And we wanted to make sure that our small businesses had the opportunity to participate. So we are so excited to partner with DRCVI today to finally bring you such an important webinar on ADA and FMLA during the pandemic. Just a couple house rules. We do ask that everyone keep their audio on mute as well as your videos off. And then you can also, if you have any questions, you can always feel free to raise your hand, and you can find that icon down at the bottom if you click on the three dots, or perhaps it says more, depending on whether you're joining from your phone or you're joining from your laptop today, and you click on raise your hand, and then we will be glad to unmute you, and then you can ask your question. And if you're feeling a little audio shy today, you can always place your comments in the chat. And then for those who are joining us on Facebook, know that we are keeping our eyes on our Facebook page, and so we'll be taking questions and comments from Facebook as well. And so without further ado, I would like to introduce Miss Shami Carr.
Good morning, Chanel, and good morning, everybody. And thank you so much always to the Economic Development Authority to welcome us and to partner with us. We've been doing this for almost a year now, and we'll actually be celebrating that in July. But this is another opportunity where, as I was talking to Chanel about this topic, it's such an important topic. We've got so many things going on in terms of different, what I call intersectionality. So that's what we're really going to talk about today is the intersectionality of the ADA and the FMLA during the pandemic, obviously specific to COVID-19. Okay, so I'm myself having a little bit of technical difficulties. That's why I'm not on video, or I'd at least say hi to you. But Chanel is going to do my slides, so I appreciate the assistance. And like Chanel said, if you have questions, feel free to interrupt. I will say the little housekeeping with me is I was telling Chanel earlier that this is a very, very heavy topic. And so we're going to get through as much as we can, and do feel free to follow up with me individually, either based on the content of the conversation or just based on the fact that maybe we didn't get to anything specific per the whole PowerPoint. We will be sending the PowerPoint to you after the presentation, so feel free to just listen, take notes. And again, if you have questions, feel free to ask. So with that, Chanel, we'll go to the next slide. So today the hope is that, and again, it's if you're new to this field, or if this is something that you don't work with too much, it can be a little bit overwhelming. So really going to try to help understand the intersectionality, as I mentioned, of the ADA and FMLA. We'll do definitions. We've got some charts, different ways to present this information so that you get a good understanding. Also, to be aware of the new IRS tax incentive for small businesses that's pandemic related, including vaccination, a leave related to leave with vaccination. There's also some other provisions. I'm going to make sure that you know about it. If we get a chance, we'll go on the website so that you see it's an FAQ, but at the very least, we're going to talk about that as a new resource to you. And there has been some ongoing resource, I believe, through the CARES Act, but through the rescue plan, there's some additional ones we want to tell you that just kicked in. And lastly, trying to leave on a much happier note when we talk about medical leave is alternative ways to help employees to avoid taking, namely in this case, sick leave. That's something that employers have gotten very creative, and I believe anybody on the line would probably say the same, is that people have really, employers particularly, have become very creative to help not only kind of maintain your workforce. Of course, there's a lot of moving parts, whether we're talking about virtual or in person, but also just morale. And of course, we know there's a lot of fear. So really just want to come up with, some cool tricks and some ways that employers have been trying to really re-engage their employees so that way they can maintain their workforce while they get through the pandemic. Okay, next slide, please. So let's just start out with the reasons for people are taking sick leave. There's all sorts of types of leaves, of course. We're not going to really talk about any of them today, but I will refer to them. But the reason that people, take sick leave, we're talking about obviously illness. Usually we're talking about illness or an injury or some sort of situation within ourselves, personal leave. Sometimes people take leave to take care of their family and caregivers, many a times. Vaccination to keep it current to what we're talking about today, certainly with COVID-19. Mental health and other medical treatment, we know clearly that mental health has been on the rise. We sadly know suicide's been on the rise. So we definitely want to make sure that one of the reasons that employees might be asking for sick leave, but it's really more related to mental health, which of course can count to be able to support an employee going through something like that. Also, substance abuse, that's been on the rise as well. And so subsequently, or a residual effect certainly of the pandemic, is people's use of substance abuse and alcohol. And so that might be a reason why someone is taking sick leave now. Maybe they're using vacation and personal first, but then they need to use some of their sick. So, that can get a little tricky because sometimes people don't want to disclose about the substance abuse. But the reality is that this is something that's currently going on, why some employees are taking sick leave due to, unfortunately, this new situation they're dealing with substance abuse or alcoholism. Of course, the reason for sick leave is COVID-19. And sometimes someone already has a disability, then they get COVID-19, and then they may need some additional accommodation. And so that's a layered type of sick leave. And under the ADA, you can do temporary reasonable accommodation. So this might be one of those situations where it's related to COVID-19 and the person might need some additional support with not just the disability, but also with the COVID-19. And then sometimes there's other reasons that people take time off, certainly for sick. But those are the majority of reasons. And again, we're going to stay pretty focused on COVID-19. Some of the effects of that including mental health and substance abuse. But again, we will talk about it in the full context of the ADA and FMLA. Okay. Next slide, Chanel, please. So as I was mentioning to you, we're going to provide this information in multiple ways. So one of the ways to really try to bring this home is to do a little bit of a comparison. So let's kind of compare ADA, FMLA, and then short-term or long-term leave. Okay. So when we talk about the first column, which is the ADA, and that's the reason and how it falls under leave falls under ADA, is called reasonable accommodation with flexible leave policy. And so this is where when someone says, I'm a person with disability, I need an accommodation related to leave, and this is the specific conversation or a category it would fall under. In terms of ADA, generally speaking, any small business, and again, I don't know in terms of the composition of anybody on the line, but if you're a small business that has 15 or more employees, that triggers the obligation of the ADA. So if you're a sole proprietor, if you're mom and pops and have 5 employees, this doesn't trigger the obligation for ADA, nor will it trigger FMLA when we talk about that shortly. So again, 15 or more employees, that can also include the owner, and that can include part-time employees. The employee has to meet definition of disability to be covered. So in terms of definition of disability, a person first has to be a person who has a physical or mental impairment that substantially limits a major life activity. So that's one part of the definition. But the other part is that they also have to be qualified for the position. So we are kind of presupposing that they're past that definition, they've qualified, and the employee has met the definition of disability to be covered. Excuse me. And in terms of time, time is not prescribed, but left to the employer and employee to negotiate. Now, unlike FMLA, which we'll talk about next, which is more prescriptive, ADA is not prescriptive in that respect. And we're going to talk about different ways that plays out when it comes to FMLA. So again, with the ADA, we're talking about flexible leave policy, being an employer of 15 or more, making sure the employee actually meets the definition to be covered, and that time is not prescribed but left to both parties to negotiate. Now, let's switch over now to FMLA. FMLA, which most of you probably are very familiar with because of the fact it's so broad, it's much more general, certainly, I would say, than ADA. But some of you may not be actually covered because, first of all, for an employer to be covered, the employer has to have 50 or more employees. So that's a lot more than the ADA. So if you don't have 50 more employees, not only, oh, hello, does someone have a question?
So I would say we do it.
Oh, okay, wasn't sure if someone had a question, but feel free to let us know. Um, So FMLA in terms of covering 15 more employees. So again, if you are a business that does not have 50 or more employees, but you have say 25, you may not be covered under FMLA, but you'd be covered under ADA. If you, as the example I used, is a mom and pops and you have 5 or 6 or 7, clearly you're not going to have obligations under either one because you don't meet either one of the thresholds. Okay, so FMLA has a much larger threshold of 50 more employees. There's some specificity about within 75 miles and so forth, but just generally 50 more employees. Also, for an employee to be covered, they actually have to meet 2 definitions as well. They have to meet the definition of must work 12 months or 1,250 hours within a year and meet the definition of serious health condition. And so both of those have to be met, just like ADA. Once both of those are met, then the employee is covered. So that gives you a sense of the employer being covered, then the employee being covered. And now when it comes to the time off, the leave, FMLA is very prescriptive, as I mentioned. It's an allocated time, allotted time is 12 weeks non-consecutive within a 12-month period. And I know it wasn't too recently, but it was something that was amended with FMLA. And again, I don't know if it's 10 or 20 years ago, to say that they didn't have to be consecutive. And that's something that was very helpful because sometimes people were dealing with either episodic or sporadic or situations that would come and go. And that gave them a chance to take FMLA opposed to taking it a consecutive time off all at one time. And there are some additional prescriptive allocated time or allotted time for people in the military as well. Okay. So now we talked about ADA, we talked about FMLA. Most employers, and again, small businesses, are going to work within the context of those 2. Now, some employers, but a lot of small employers don't always provide an opportunity to have what they call to purchase short-term or long-term disability. Individuals can buy, employees can certainly purchase things like AFLAC and different types of short or long-term disability leave, but that's on their own kind of dime. And it does give them some coverage in the sense of financial assistance, but it doesn't necessarily always help them when it comes to the time off. Okay. So it's kind of a split situation with short-term and long-term leave. Now in the states do have what they call a state disability program where if you are out of work due to illness, injury, or disability for a week, then the state will kick in their short-term disability. Now, I apologize, I don't know of one in the Virgin Islands. If there is one, if anybody knows, please feel free to say. I have yet to see it, but again, I'm not 100% expert on that one. So talking specifically about this, that this is specific per the employer or the employee, as I just mentioned. Employers sometimes provide them, sometimes they do, sometimes they don't. Employees sometimes purchase them, sometimes they do, sometimes they don't. So the employee now either has time accrued or their own short or long-term policy. So basically that's saying that someone might have beyond sick leave, they may have personal, they may have vacation, they may have other crew time. I'm not really sure of any other ones, but let's just say they have other non-medically or non-illness related time off. Well, now they could take some of the sick time off and then still be able to leverage in terms of the financial assistance. So the short-term, long-term leave gets a little bit kind of funky because there's so many variables based on who's got what policy. But it is good to know because it can play into ADA and FMLA. But in terms of specifically that it's not going to necessarily affect the accrued time in terms of it's just going to help with the financial. As everybody knows thus far, ADA does not provide any financial assistance during leave time. FMLA does not provide any financial assistance during leave time. And the short-term, long-term policy can provide financial assistance when it comes to that. Okay. So Chanel, I'm going to take a pause here and see if anybody's got questions or comments based on this chart.
So no comments in the chat, Chami, and no comments right now on Facebook as well. Looks like you're providing succinct information. Much appreciated.
Sounds good. Thank you, Chanel. Sounds good. It can get a little complicated, so I definitely want to make sure that people, if you've got a good basis for this, just right here alone, you as an employer will be that much further ahead. Now, I'm not foolish to know that it gets very complex in terms, you've got regulations, you certainly got laws, and you've got different, and I don't believe most employers who are small usually don't have unions, but if you did, that just adds another layer of complexity. Okay, so Sean, I'm going to do the first polling question, and if you're ready, or I can just read it, it's on the next slide. Okay, so I wanted to ask the audience, and I know we've got a fairly small audience. I hope so everybody can answer this, but do you currently have an ADA policy that addresses flexible leave? It's either yes, no, or unsure. So do you currently have an ADA policy that addresses flexible leave? And Chanel, you can let me know when people have answered. Okay, see if Donald said no. Okay, I could see that.
And we were just able to also launch the
Okay,
poll.
wonderful.
If you'd like to go ahead and vote. Do you currently have an ADA policy that addresses flexible leave? We've got some answers coming in. Hopefully some more folks can vote. All right, all right. 20 more seconds for voting. 10 more seconds. And the time is up. So 60% said yes, Shami, and 40% said no.
Okay. Okay, that's good, at least more than not. And as you probably know, the 60% that does have the flexible leave policy, it is that intersectionality to make sure that not only are you following FMLA in terms of what those more stringent or I think more prescribed rules are, but then the ADA where there's a lot more negotiation that can be had, and to make sure that employers know how to really balance the two out. So I'm really glad to hear that some of you, certainly a lot of you, do have that policy. And again, please chime in. I do have a slide at the end. Hopefully those who do have flexibility policy, if you want to chime in and maybe talk about a situation if you feel comfortable, and hopefully we'll have time to do so. So thank you again for that polling question. Okay, we'll go to the next slide. Chanel? So I want to hone in first on ADA, and then we're going to hone in on FMLA. So let's hone in on ADA. It is the ADA Act of 1990. The anniversary is actually just coming up in July 26th. It's a broad application for people with disabilities, including non-obvious. A lot of times people ask me, and I'm still surprised, in 2021, do people who have mental health, people who have disabilities you can't see, are they included? And they are absolutely included, so non-obvious. Mental health and substance issues and their applications. And that's something that I already mentioned in the context of COVID-19. And sometimes I know a lot of employers didn't even know that if you have had a previous substance abuse issue or alcoholism and you've been in rehab and your rehab, you're actually a person with a disability under the ADA and you are protected. And so that's very helpful for not only employers to know, but also employees too. So if you know of employees that have dealt with that, and if you know, for whatever reason you happen to know, do know that they do qualify under the ADA in terms of that application. And also with ADA, a lot of times people get a little confused with temporary versus permanent. Now I mentioned in the beginning about temporary reasonable accommodation. That's different from temporary disability. Okay, so temporary disability is someone who maybe gets injured and is going to have a typical recovery. Anything from a broken leg to maybe a car accident, a situation where the prognosis is favorable and the person will pretty much be restored to where they were. That's a different type of disability than a permanent disability. I mentioned to you the definition, which is, again, a physical or mental impairment that substantially limits a major life activity. And that substantial limitation is what makes it permanent and not temporary. So there's no magic number when we talk about permanent. Some people will use, a kind of a rule of thumb of maybe 6 months or a year, but there's really no magic, certainly amount of time. But the most important to know is that the ADA is covering permanent disabilities, disabilities that are ongoing, and disabilities that aren't necessarily going to go away, or at least not for a long time. Okay. We'll go to the next slide, please. So defining the ADA. And I mentioned this already, so I want to make sure you guys have the actual definition of the ADA again. Physical mental impairment that substantially limits a major life activity. That is literally pulled right from the ADA. That's also a very common definition for other disability rights laws. So if you've seen that definition before, that's why. As I mentioned, private employers with 15 or more employees. And what really the biggest, or I say the most meat to the ADA, really talks about reasonable accommodation. And reasonable accommodation is an adjustment or a change on how something is customarily done. Okay. And then leveraging paid or unpaid leave is a form of reasonable accommodation. And that's that column that I was talking about with the ADA, that flexible leave policy. That's where it comes under the reasonable accommodation under the ADA. Okay. We'll go to the next slide, please. Okay, so flexible leave under the ADA. So we talked a little bit about ADA in terms of who qualifies and employers, how they qualify, and some of the little bit of nuts and bolts, but let's get a little bit more specific talking about the flexible leave policy. And again, if you have questions, please don't hesitate to raise your hand or let us know. So the first thing, again, with the flexible leave policy, as I've already mentioned this a couple of times, a worker must meet the definition to qualify, both the definition of disability and also being qualified for the position. This is a form of reasonable accommodation and subject to undue hardship. And we're going to talk about undue hardship in a few minutes, because that is something that is definitely, a safeguard for small businesses when it comes to providing these reasonable accommodation. If someone has a leave, and I'm going to mention it now, and I'm probably going to mention about 4 more times through the presentation. If someone asks for a leave, and that actually jumps to the 4th bullet, for indefinite leave under the ADA, that is a hardship. I can't imagine too many situations for a small business where someone says, I need indefinite leave under the ADA, and the employer says, no problem. Okay. I think that is not only not reasonable, but the ADA was never intended to break the bank of small businesses. It was never intended to change operations. And we're going to talk about that very specifically when we talk about undue hardship. Okay. A flexible leave policy can also be used in conjunction, as I mentioned, with FMLA. It could also work in conjunction with light duty and also with workers' comp. So you can see, again, a lot of different intersectionality when it comes to flexible leave policy. Again, we'll talk about a couple of different ways to make it a little bit more concrete. I was just talking about the indefinite leave, and that's just not ADA, that's also FMLA. So indefinite leave is not a form of reasonable accommodation and cannot be used for temporary disability, as it does not meet the definition of substantial limiting, as I mentioned, when it came to the definition of disability. We'll go to the next slide, please. Now let's talk a little bit specifically about ADA leave and COVID-19. Now, ADA, to be very, 100% sure that employers know that ADA cannot be used for anyone but yourself, not as a caregiver. That's FMLA. So if you yourself, or your employee is dealing with COVID-related 19 effects, whether they had it or they're having residual effects, they then can leverage ADA because it's for themselves. And if they meet the definition of disability, which we just talked about, if those residual effects of COVID-19 meets that definition, then they will be a qualified person with a disability. One thing to note is that many people ask, is there a list? Is there a list of disabilities that the ADA covers? And there is not a list. And that was specifically done because of the fact they didn't want to make either a disability included or not included. Two people can have the same disability, but the way it affects them might be less on one than the other. So it's always on an individual basis, never based on a diagnosis or condition. It's based on how the disability manifests. So very important to know in terms of who qualifies, who doesn't qualify. Okay, so also when it comes to ADA leave policy and COVID-19, we just talked about can provide reasonable accommodation as long as they qualify. And here are some of the things or accommodations that might be helpful. It could be accommodation related to, again, leave policy now, to illness and recovering from COVID-19. It could be the vaccine and any effects of it. It could be mental health, which we were just talking about, including depression. And it could be related to rehabilitation from substance abuse. Now, just to play this out, let's say that you have someone who has disclosed to you that they are dealing with a substance abuse or alcoholism situation, and they want to talk to you. And now, just by them saying that, they've disclosed, quote unquote, a disability. Now, if they say they're in rehab, they're an outpatient, they're seeking support, whatever that means, as long as they're not using, then at that point, that can be considered a disclosure. Once they disclose that, then at that point, if they say to you as an employer, I would like to be able to address my condition, I might need some time off, I want to be able to start to have that conversation to know if that's reasonable and what that might look like. Then at that point, you are having that conversation. And also for employers, you actually can ask for medical documentation or disability documentation at that point because they've disclosed a disability. Okay, so I just wanted to play out a scenario when it comes to leave policy, something related to COVID-19, but not necessarily COVID-19 itself. And again, in asterisks, I've got it in red. Again, as a reminder, temporary disabilities will not qualify for this form of reasonable accommodation. Next slide, please. So this is the slide that I think is probably one of the most important for small businesses, not because it's not a situation where it's okay, good, I can get out of this, or I don't have to do this. It's more of, okay, first and foremost, the ADA was set up to make sure that it's reasonable. And if it's not reasonable, I'm protected. The ADA was also set up to not have knee-jerk reactions. And so that's why when we talk about this, you'll see how that plays into, instead of having that reaction, having more of an analytical reason, okay? So the undue hardship, okay? The leave, again, the leave we're talking about with ADA specifically, the leave cannot disrupt the operations of the business. I use the example of indefinite leave that absolutely will disrupt the operation of the business if someone is working full-time, isn't, an essential worker or part of the staff, that's going to be disruptive. So that is not the purpose of the ADA, is to have employers disrupt their business just for the sake of reasonable accommodation. The leave cannot fundamentally alter the nature of the business. And again, another protection for the small businesses to say, this leave is really making my business different, or it's changing the nature, or we don't usually do services like this, so this accommodation is making me change. None of that is required. Okay, none of that is required for the ADA. What is required is to have that conversation to decide, again, not that knee-jerk reaction, to decide, yes, this is reasonable, or no, this is not reasonable. An example I used was fundamentally altering the nature of a business, and it's not related to leave, but just to give you an example, is let's say that I have to take medication in the morning and I don't work as well and I do better come 12 o'clock on. Well, the business is only open 9 to 5, and I'm asking to work full time, but I'm not going to come in till noon. That's not reasonable. Not only is it not reasonable, it's fundamentally altering the operations of the business if I'm needed there from 9 to 5. So that's just a quick example of fundamentally altering the nature of the business, including hours, certainly. And exceed their resources, including cost. So the leave, again, I will say it again, that the purpose of the ADA is not to bankrupt anybody, not the government, not the small businesses, not the employers. The purpose of the ADA is just to provide a level playing field so that people with disabilities can have equal access. So with that, if the request you're getting is exceeding your resources, and I put the caveat about the pandemic because EEOC has already stated that if profits lost during the pandemic is making it even more difficult to provide reasonable accommodation, then that's even more of a reason you don't have to provide the accommodation. Okay, because you're already at a loss with the profits. Now someone's asking for accommodations. And if it's just undue hardship of cost, then you're justified. And all of these are really important because, again, as I mentioned, it's not that knee-jerk reaction. It's saying, okay, let's look at the analysis. Let's look at the situation and see, is it possible we can work around this? Is it possible? If it's not, at least it's justified. So no one's making a quick decision or a rash decision. I want to say, I feel like I've seen some of the analytics or the analysis that they use to determine some of this. I feel like I've seen it, and it's something that's step by step. There's nothing that's a quick answer, and there's nothing that's a knee-jerk reaction. And I want to mention that over and over because the whole reason for the ADA is to have that civil rights. And sometimes that civil rights has been very much hampered, if not really downtrodden because of the fact of stereotypes, knee-jerk reactions, and so forth. Okay. All right, one thing, and I really apologize I left out, which should be on here for undue hardship, also is direct threat. Okay, so I apologize. I will add that before we send this out. Direct threat is another part of undue hardship. Someone coming in with COVID-19 is a direct threat. That's already been determined. So a direct threat is any situation that a person with a disability may pose that is a hardship for your business. I was just talking extensively and kind of philosophically about the ADA and civil rights and knee-jerk reactions. Well, this is one part with direct threat, where it is a situation where people with disabilities were so treated poorly because if they had a mental health, oh, they must be crazy. Oh, they're going to go postal. Oh, they have AIDS. Oh, something bad's going to happen. I'm going to catch it. So, the whole issue of direct threat has been around obviously for a long time. And this is a situation where we want to continue to curb that. And employers that honestly, I could tell you from my experience talking to so many employers, there's two reasons why employers don't want to hire people with disabilities. One is the money, and two is the direct threat or the stereotyping. Okay, so these are very, very common issues. And it's kind of unfortunate because the purpose of the ADA was to mitigate those situations and to still put the control, in my opinion, in the employer's hands still, because at the end of the day, the employer makes the decision about the reasonable accommodation and if it's a hardship or not a hardship. Certainly, employee can challenge it, but the ADA was specifically written to make sure that the covered entity, in this case, the employer, has, I don't want to say the upper hand, but they do have the ultimate decision making in that. Okay. All right, we're going to go to the next slide, please. Okay, so now we're going to start to talk about some intersectionality. So when we talk about ADA disability, is it a FMLA series condition? Okay. So an employee has to meet both definitions to qualify to leverage both ADA and FMLA. Just like I was talking about with the employers where, it's 15 or more for ADA, and 50 or more for FMLA, the employee also has to meet both definitions. Okay? An employee, and again, when it comes to um, the ADA, and again, it's been in the PowerPoint a couple of times, the employee must first meet the ADA definition, which is the physical or mental impairment, but they also have to meet a serious health condition, and they have to meet the 50 more employees, and they have to meet the work requirement of the 1,250 hours within 12 months. So you can see there's a lot of check marks that have to be had to make sure that this person qualifies. So it's not an easy process. That's why I mentioned this is a fairly heavy presentation. And like I said, if anybody has questions afterwards, be happy to follow up. Because as you can see, just the second bullet alone has so much information that teasing it out can even be difficult. Okay, unlike FMLA, which has a work requirement, ADA does not have a work requirement in terms of working X amount of hours. The only work requirement that they have is the second prong of the definition of ADA under Title I for employment is being a qualified person for that position. Okay, we'll go to the next slide, please. So as I mentioned, we're going to try to present this in a few different ways to just try to understand the intersectionality. Here's another way to try to provide this information to you. So the first is the ADA, which is the top part. And I want to bring up some things that we haven't talked about yet. Under the ADA, and this is also true for FMLA, that the person does not have to be 100% healed before returning to work. I'd mentioned previously that ADA flexible leave can also be used upon light duty. So when someone returns to work with light duty, that's an opportunity where someone's returning to work without being 100% healed. Limit documentation or document of disability to just the leave request. This is something that's really important because many small businesses and small employers don't have a whole bunch of room. They may not have a whole bunch of storage. They may have a lot of cloud storage, but in terms of kind of the setup, it can be smaller certainly. And when you're talking about ADA, talking about FMLA, and then there's HIPAA, which I'm really not talking about today, HIPAA, but that's a whole nother part of this conversation, is you've got, as a small business, you've got a lot of different organizing to do, even within your HR department, because again, the personnel files should not be mixed with the medical files, should not be mixed with the ADA files. So being able to make sure that when you ask for documentation of disability, just ask for the leave part of it, because that will be less documentation that you have to keep, but it's just also easier to manage when it comes to documentation, okay? And I will tell you that I tell employees and job seekers with disabilities, their responsibility certainly is to provide the documentation of disability, but I tell them never sign a release to an employer, because that means they have access to a whole bunch of information that they probably don't need. And humans are humans, people can be nosy, and so this is just a way to try to kind of shut that door and everybody be in good control of the documentation, both the employees to know what they need to provide and keep it short and sweet and appropriate, and for the employers to also ask for it to be appropriate and not to, of course, share it with anybody, and to have it in a very secure and a very confidential storage situation. Okay. Under the ADA, pregnancy can count if there are complications. And so usually pregnancy does not count. It can fall under different kinds of accommodations, typically related to the human rights laws. Okay, so that's where pregnancy typically falls under. But if there's complications and there needs to be additional leave due to that, then they could qualify under the ADA for that reason. And lastly, I want to mention with the ADA, which I mentioned early on in the presentation, is to treat obvious disabilities the same as non-obvious. So just to give you some examples of non-obvious, or you know what, Chanel, let me ask people out there, what do you consider non-obvious disability? You can just put it in the chat. What would you consider non-obvious? Anyone out there? don't know if you have a shy group or people just waiting to jump in. I think we have a very
Oh, it
What
sounds like someone coming on.
I'm trying to think. What because you can't necessarily tell if someone is deaf unless you're talking to them and they can't hear if they don't have a hearing aid in.
right.
What about someone with arthritis?
Hmm. Correct. And deaf is a very good example because just looking at the person, you wouldn't know, but once you start communicating, you immediately know. And arthritis and other types of physical disabilities, excluding, of course, scooters and wheelchairs and crutches and braces, is something that many times you can't see. Back impairment, you can't see many times. So yes, those would typically qualify or be listed under non-obvious disabilities. I think someone was asking colorblind. Is that I think I just saw a comment about colorblind.
Yeah, someone said that being colorblind, that may be considered an impaired ability that is not obvious.
Yeah, and that's a very tricky one. When it comes to different types of visual disabilities, it's a very long slope, and it's not a slippery slope. It's just a long slope because you have a lot of different severity. And color blindness, actually, I have really not heard too much of ADA applying. Some people have said, well, I only have one eye, or I can only hear out of one ear. Well, that's not always going to be significant enough. So it's hard to say with colorblind. It depends really on how it impacts that person and to what degree that it may be qualified, even under ADA. But if it did, it definitely would be a non-obvious disability, 100%. We think about medical conditions, cancer, MS, diabetes, sickle cell. We talk about mental health. There's so many: bipolar, depression. Depression is the number one, sadly, very sadly, number one disability in the world, along with back impairments. So, substance abuse falls under mental health as well. So there's a lot of non-obvious learning disabilities that falls under. ADHD can also fall under non-obvious. Okay. So I just wanted to give a quick shout out to all the non-obvious disabilities to make sure that people know 100% they qualify under ADA. Okay, so we'll go back to the slide. So let's quickly talk about the Family Medical Leave Act. Now, we just talked about some of the features of ADA. Now, in terms of Family Medical Leave Act, as I mentioned, it can be used sporadically. It does not always need to be consecutive. Again, if let's use the example of someone dealing with a substance abuse situation. Maybe they're going to need to go for in treatment for a month or 6 weeks. Then they come out and they use their family medical leave, up to the 12 weeks, they used half of it. The other 6 weeks they're going to use for outpatient, which they need to go twice a week. So that's a way to spread it out, use it sporadically, use it intermittently, and make it work for that person. Because at the end of all of this leave, you want your employee to come back ready to work or the best of their ability. Okay, it doesn't have to be 100% healed, but the purpose of these leaves is so the employee can return to work. Okay, and we'll talk about what that means, exactly what it means to return to work. Okay. FMLA, as I mentioned, can be used for serious medical condition. That's mainly what we're talking about today when it comes to COVID-19 particularly. But we know that it's also used for other situations like birth or adoption, foster care of a child, to care for an immediate family member. Certainly if you've got a family member who has had some very difficulty or effects from COVID-19, may not qualify under ADA, but may qualify under FMLA to be able to care for that person. Does not allow indefinite leave, just like the ADA. And after the 12 weeks are exhausted from FMLA, whether they're consecutive, sporadic, intermittent, after the 12 weeks are exhausted, ADA can kick in for additional time off under the flexible leave policy. And that's really where rubber hits the road when it comes to ADA leave policy, because if someone's leveraging FMLA, they've already have protection right there in terms of being brought back to work. Now, what ADA is doing is giving that person after 12 weeks, they're giving them some additional time. Again, not prescribed. This is negotiated between the employer and the employee to decide what is reasonable after, taking FMLA. So this gets very, very complicated. And this is a very extensive conversation and something that is not taken lightly, because you want to make sure, one, as a business, you're able to continue your operations and not have that disruption as we were talking about. But at the same time, you certainly want to, and I do think that many employers do care for their employees. They really do want them to see them to get better and to come back to work. Okay. So just another way to talk about FMLA and ADA, and we'll go to the next slide, please. Oops, Chanel, if you can go to the next slide, please. All right, thank you. One thing that came up when we talk about leave policy, and I think this is a very interesting angle. Matter of fact, a good friend of mine is dealing with this as we speak. Call this no-fault policy. And a no-fault policy can be discriminatory because sick leaves are sometimes treated as a negative or a fault without taking into account both the ADA and the FMLA protections. Okay. Now, I'd be curious to know if how many people are familiar with a no-fault policy. Many a times you're going to find this in more unionized environments, but this is something that can be across the board. So if you have any experience, feel free to jump in or throw a chat in there. Basically what it's saying is that FMLA and ADA leave should be treated as qualified leave. This is not a situation where you, and I've heard this many a times, you partied all weekend and then you're out Monday, Tuesday, Wednesday, okay? And you didn't call in, and now all of a sudden the third day you could be potentially terminated. A lot of places, if you're not in for 3 days or don't call in, that's no show. Now all of a sudden you disclose to them upon the termination, oh, well, I just want to tell you I've been having a drinking problem and I really want to try to, well, it's too late. You've been terminated. Anytime you've been terminated, you do not have to provide reasonable accommodation to bring them back to work. But let's play this out differently. Let's say that this person was in rehab and had a bad weekend and fell off the wagon and was out for 3 days and called in and said, I'm not feeling well, didn't say specifically why. And then the third day they came back and they had that conversation with you, and to say, listen, I took these 3 days off. I called in, so there's no fault. There's no negative consequences, but I called in, I followed the protocol. Now I'd like to tell you specifically why I called in, and can we, have a very private and confidential conversation about what I'm continuing to deal with. Okay, so those are two different ways how you have a qualified leave and a not qualified leave. Not showing up to work is not a qualified leave. Okay, asking for time off, getting approved is qualified leave. Calling in sick the day and following whatever protocol is for that day or for those 3 days, whatever it is qualified leave. Okay. FMLA and ADA should be treated equivalent to other approved leaves such as personal, vacation, bereavement, and more. So basically, as I mentioned, I have a friend. She has been out of work for 7 months due to a disability. Now the union has let her know that those 7 months will be put in the back and you will have to work the additional 7 months to continue to retire when you want to retire. They basically have used it against her, even though she used qualified time off. Okay, so if you know of people who've had qualified time off due to a sickness, illness, or disability, and they have been punished or punitive measures, that is not legal. Okay, and this is what that no-fault policy is related to. And basically, that these leaves should not result in a manner that is retaliatory. Okay, so this is a very important situation, because as you're looking to either approve time off or not approve time off, basically whatever you do, especially if you approve the time off, is not to use that against them, because this should be treated as like a vacation or personal. Clearly, when people are taking sick time, it is not a vacation, but I've known people who've taken vacation time when they're sick. Okay, so I just want to really bring that home when it comes to no-fault policy. And if you've got questions, jump in, ask, raise your hand. We've got about a little less than 10 minutes. I want to leave a couple minutes. Again, I know Chanel's got a couple of things to close up with. So let me try to get through some about 5 minutes, but again, do not hesitate to jump in and ask questions. So I was talking about when ADA and FMLA, what's the job protection? When people return to work, what can they expect? Okay, so when someone takes a leave and they return under ADA, the employee has a right to return to the same position, barring any undue hardship. Okay, so if leaving that position open for weeks and months at a time means that you are allowing your employee to take the time off, but you've actually brought in someone else to do their work. Okay, so now it could be that months have gone by and that person is continuing to do that person's work, and now the employee wants to return. While the employee, if they use a temporary maybe service, that might be okay, because maybe temporary fill-in. But if it's someone who ended up working there permanently, then that might not be a position that was held, because the employee had a right to continue their operations and they needed someone to continue to do that work, even though they still supported you and gave you as an employee also rights to be out due to a medical situation. So when you return to work, you may not get the same position, but hopefully a position that is similar, or maybe a vacant position. So that's what job protection is under ADA. Now, job protection under FMLA is slightly different, where the job protection says restored to their original position or equivalent. Okay, so a little bit similar to ADA with original position or same position or equivalent. And so again, to me, this gives actually a little bit more protection, in my opinion, as an employee, because let's use that example that we did with you were out for months and the employer brought someone in to do your job. Well, maybe when you come back with FMLA, because someone is doing that job, now the employer has to find you something equivalent. Equivalent meaning typically same benefits, same pay, same type of work. Okay, so that's what job protection is under both of those laws, both ADA and FMLA. And Chanel, we're going to skip a couple of slides or scenarios. We definitely won't have time. We'll go to slide 17. I want to definitely mention the IRS real briefly. Okay, great, thank you. So as I mentioned in the beginning, the IRS, FMLA COVID-19, they have a tax credit fact sheet. And under the American Rescue Plan Act of 2021, enacted March 11th of 2021, amended, and I'm not going to read all the rest of it, but basically saying beginning April 1st, 2021 and ending on September 30th, 2021. So here's an opportunity where you can get some tax credits, and this is related specifically for paid sick and family leave for wages paid with respect, and again during that period. So check that out. I think that's going to be a big relief for a lot of the small businesses, and I've got the link there for you, and that will take you to other FAQs and fact sheets that they have, but this is the one that's very specific related to the one for paid sick and family leave. I thought it was obviously right in time with what we're talking about today to make sure you know that that is going on and to take advantage of that. Okay. We'll go to the next slide, please. And on my 1.5 minute that's left, I do want to talk about alternative flexible ways to support your employees. And if people can see the visual, there's a picture of a woman in a wheelchair, and that's a good friend of mine, and she knows how to keep life well. And she's a great role model for anybody, disabled or not, to keep a positive attitude in life. And she's a good friend of mine. That's Chelsea. So when it comes to ways to support and make you feel as great as she does, some things you can do, and again, some businesses are already doing this, but you can definitely offer incentives. I know a friend of mine got offered an incentive to take the vaccine. He took it, $50, a gift card. Create or make aware of self-help resources like telehealth and EPA programs. Increase professional development opportunities to keep your employees engaged. And that's where you could certainly talk to labor about some of the trainings they're doing. Provide a nutritional program or a nutritionist. Believe it or not, they were saying that's one of the biggest a support that's been to employees because of the pandemic and because of people just feeling so depressed. So nutritional program or nutritional information or even a nutritionist is really awesome. Revisit your work-life balance as a policy or practice. Revisit that. I know a lot of employers are revisiting their telework or their virtual working. I can be assured of that. Be flexible with sick leave, including mental health and stress. We did a presentation a bit ago about mental health and stress and making sure that employers will help to kind of help maintain some of that because there's a lot of unknown right now with the pandemic. And throw some virtual parties. It's a great way to reconnect and socialize. They do put a lot of caveats. Like I wouldn't really recommend a lot of alcohol, but why not? You know, Zoom's got some really fun stuff on there to be able to engage. They've got different ways to do parties, whether it's retirements, birthdays, you know, socializing. You know, just go right into it and see what you can do. You know, employees would like that even once a month, just to do something to reconnect until people can really reconnect in person. The reference is down there. The link is down there. And with that, let me just mention as I close, if we could go to slide 21, please, the Northeast ADA Center one. Chanel, if we can go to the Northeast ADA slide, I believe it's number 21. Great, thank you so much. And I thought we would be over time when it comes to some of the information. There's some really good resources in the slide above, but I do want to mention our partners, the Northeast ADA Center. We are an affiliate of them. They're out of Cornell University. They provide technical assistance and training regarding the ADA that includes physical and programmatic access. I myself work there. It's a great resource. They're actually celebrating their 30th anniversary this year as well, being in existence. You can reach them toll free in the Virgin Islands at 800-949-4232, or you can email them. And the last slide is who we are, the Disability Rights Center. And if you want to go to the last slide, Chanel, the Disability Rights Center. All right, great, thank you. So again, my name is Shami. I'm an advocate at the Disability Rights Center. We're part of a national network called Protection and Advocacy, and our mission is to ensure the just treatment of people with disabilities. We provide advocacy, information, and referrals, guidance, legal advocacy, and training. As I mentioned, we are an affiliate of the Northeast ADA Center. They provide us resources to provide the community with free trainings. That's why we ask at the end for the evaluation so that we can provide it to them. And for us, you can reach us both St. Thomas, St. John at 340-776-4303, St. Croix 340-772-1200. And with that, I'm going to hand it back over to you, Chanel, and thank you very much for your attention today with this presentation.
Thank you so much, Shami, and thank you all for joining us today at the VI EDA Wednesday webinars. We are so happy to have partnered with the Disability Rights Center of the Virgin Islands. And I see that we are just at 11 o'clock a.m., so right on time. And there appears to be some comments in the chat. So yes, we've got your information, Mr. Stevens. Thank you as well. And again, if you are interested in seeing this recording, you can visit our website by the end of the week, www.usvieda.org/webinars. And of course, stay tuned by liking our Facebook page, following us on Instagram and on Twitter. And as well, you have the option to subscribe to our email list found on our website, usvieda.org. Thank you all so very much for joining today and have a wonderful week.